Yes, I am here, if you can hear me. Let me read you a little bit of what we have from the court. It does find this. Under our constitutional structure of separated powers, the nature of presidential power entitles a former president to absolute immunity from criminal prosecution for actions within his conclusive and preclusive constitutional authority. He is entitled to at least presumptive immunity from prosecution for all his official acts. There is no immunity for unofficial acts. That's the first blush we've got on this. It looks like a 6-3 split. We've got the dissent by Justice Sotomayor, Kagan, and Jackson join that. There is a kind of split decision on some of these. Somebody joins in one part, not in another part, but that's the overall holding of the court. So what it means now, we'll have to dig into this and see if they tell us now, how do you decide an official act versus an unofficial act? Because that's going to be critical, having now said the president does have absolute immunity from criminal prosecution for actions within his conclusive and preclusive constitutional authority. We'll dig in, see how they define those official acts, and look for a little bit more from you from the opinion. But at first blush, this looks like it is going to be a win for the argument for presidential immunity when it comes to allegations of criminal activity.
Well, this is along the lines of what many of us anticipated, that the court did not go with absolute immunity on everything, but did say that there's absolute immunity when it comes to core constitutional powers. We're still going through the opinion to see if there's any assistance on where that line is to be drawn. This case is going to have to go back to the district court, which is going to have to try to sort of thread this needle to determine what in the case would not fall under these protections. But this is obviously a win for President Trump in the sense that the special counsel was arguing, as with the lower court, that there was very little immunity here to be concerned with. The counsel for the government was assuring the court that they really didn't have much to be concerned with here in terms of any changes in the status of the case. That's clearly not what won the day. The court here is saying that we do need lines here drawn to protect presidents so they have some breathing room. And you have to sort of wonder how the context affected the justices. I mean, if they want to look at the implications of leaving presidents without protection, they just need to look around the country. Even though Manhattan was not a federal case, it was a political prosecution in the view of many of us that was rather raw and open. And so this is a context that must have concentrated the minds of these justices as they did what Justice Gorsuch said and tried to write for the ages, to have something not for this case, but for future cases and future presidents.
What's most significant about that is the U.S. Supreme Court could have said, we're remanding this to the district court, to the lower court, and whatever they say goes, and we will uphold that. They didn't say that.
Exactly. To the contrary. This case will not go before the election. It will not be tried before the election, and here's why. Supreme Court has just said there is such thing as criminal immunity. The test, as we anticipated, is essentially official acts versus unofficial acts. We're sending it back to the district court, and this is an important detail, the court says several times, whatever the district court finds can be appealed before trial. Jack Smith had made an argument of, well, maybe the district judge, the trial judge, can work it out and send it to the jury, and then the jury can separate official from unofficial acts. Several times in this opinion, the Supreme Court, the majority, says explicitly whatever the judge decides about what's official or unofficial, what's immune or not immune, that can be appealed back up. 0% chance that happens before November.
Do you think that if Judge Chutkan had ruled differently initially and said, it basically closer to this, the conversations with the Justice Department are clearly official acts, I'm not going to count them, but the other one, like if there had been a less of a sweeping, of course he can be indicted on any of this stuff, ruling by Judge Chutkan, would this not have been ended up where it was today? Did she open the door for a decision like this?
She did. I think Judge Chutkan's going to have a lot of regret. When she issued her opinion, it just said there's no such thing as automatic immunity for everything a president does his whole 4 years. When I was reading that, I said, okay, where's Part B? I expected Part B to be, and I find, having reviewed the record and reviewed the documents, and I find that even if there is such thing as immunity, he was outside the scope. And by the way, that's what the Court of Appeals did on their ruling. The problem is, as Jim was saying, the Court of Appeals and the Supreme Court, they're not fact finders. This can only be done at the district court level. And so I suspect Judge Chutkan is feeling some regret. It wasn't like it was some leap of logic that she should do that. This happens. There are hearings. For example, in the Georgia case, Mark Meadows is trying to get his case moved over to federal court. The question there is almost the same thing. Was Mark Meadows in or out of the scope? You know what the federal judge did there in Georgia? He held a hearing. Mark Meadows testified. He said, I find, based on this hearing, you're outside the scope.
The first one was raised by Justice Sonia Sotomayor back in, was this April? What about getting SEAL Team 6 to assassinate a political rival? Let's roll that tape.
If the president decides that his rival is a corrupt person and he orders the military or orders someone to assassinate him, is that within his official acts that for which he can get immunity?
It would depend on the hypothetical, but we can see that could well be an official act.
That was a stunning moment in April. Did the court just say, yeah, you can assassinate a political rival?
No, I don't think they did. That's a ridiculous answer by Donald Trump's team, a dangerous and reckless answer. One really important thing, the basis for Donald Trump's legal argument that maybe he can order an assassination and still be okay is this preposterous argument that they offered below that, well, a president can only be indicted if he's first impeached by the House and convicted by the Senate. The Supreme Court explicitly rejected that argument.